let's go ahead and start. Let's put the phones away. Anybody have any syllabus-related questions? The paper 3A, we've handed them back. We got it to you in both formats. We've handed them back. If you haven't gotten yours back, I should have it over here. If you haven't seen a grade posted for yours yet, then I probably don't have it over here, and that probably means you didn't give it to us in both formats, or at least not on time, or if you did, we missed it. So double check that, and then be sure to check in with me. So the final version of it is due next Monday, right? So a week from yesterday. Any questions about the paper? Okay. A couple other syllabus reminders. I said a few words about the exam last week. I'll just reiterate. It's a comprehensive exam, covers the full scope of the material from throughout the course. You should be, during the time that you have available, you should be obviously keeping up with the new material that we're continuing to cover, and to the extent that you can carve out some time, begin to go back and review some of the material, especially if there were some gaps where you weren't as fully present and engaged for part of the semester as for other parts. The best study guides for reviewing the material are the daily handouts, and they're all on Blackboard if you're missing any of them. And I do encourage folks to study together. You have to take the exam by yourself, but I encourage you to study together if you have a friend or can make a friend in the class. And I mentioned last week that if you, those of you who took Conlaw 1 with me know at least what a couple of my exams look like, because we had 2 exams in that class. If you did not take Conlaw 1 with me, if you come by office hours, I will show you the exams from Conlaw 1, just so you can see what those look like. Not that I'm saying necessarily the exam in this class will look exactly like those ones, but at least it gives you something to go on. Bless you. Okay, so come see us, obviously, if you got questions or concerns about the paper. If you have not gotten feedback yet, for some reason, because we didn't have the paper in both formats or whatever, make sure to come see us so you can get some feedback. If you did get some feedback from us, but you don't understand it really, make sure to come see us. If you got some feedback and you think you understand it and you're in good shape, then just proceed, I guess. Okay. Raise your hand if you're writing about LGBT rights in your final paper. I know there's a couple of you. Okay. So that's what we're talking about today. It's for sure been a popular topic for that assignment in recent years, because it for sure has been a major area of constitutional change over the past couple decades, right? Marriage equality in particular, which is, I guess, mostly what we'll talk about, but sort of LGBT rights more broadly, which started with some other issues before we got the marriage equality, that I'll go back and look at some of those. But at the time you guys were born, right, so like 20 years ago, basically the Constitution did not protect LGBT rights at all, right? There was nothing in the Constitution that was held to apply in any explicit way to the protection of LGBT rights. I mean, that's a little bit tricky to phrase that the right way. Obviously, like if a gay or lesbian person got arrested and convicted of a crime without being provided a lawyer, right, that person would still have the right to counsel, right? So there were LGBT people had some rights, right? They had some rights that everybody had, but their rights as LGBT persons, right, were not protected by our Constitution at all, basically. And that's not true anymore, right? So something has changed a lot in the past couple of decades. And so it's worth thinking through a little bit what exactly changed and why we think those two changes, why we think those changes took place. At the time you guys were born, the leading case about LGBT rights under our Constitution was Bowers versus Hardwick, which was from 1986, which I know for most of you is before you were born, but that was still the most recent notable case in the early 1990s. So in this case, Michael Hardwick was arrested in his bedroom for engaging in consensual sexual activity with another man, which was illegal under Georgia law. Actually, what Georgia law said was it was illegal for anybody, regardless of their sex or gender, to engage in oral or anal sex. Right? That was the definition of sodomy in Georgia's law. Right? Any sexual act involving the mouth or anus of one person and the genitals of another person was illegal and punishable by prison terms of up to 20 years in the state of Georgia. It was not often enforced. It was unusual for somebody to get arrested in his own bedroom, but it was occasionally enforced. This guy got arrested, and its most significant legal effects were that in other kinds of disputes, other kinds of legal disputes involving LGBT persons. So, for example, if there was a family law child custody dispute involving an LGBT person, right? A straight married couple breaks up, and one of the partners decides that he or she is gay or lesbian, and then a dispute emerges in court over who's going to have custody and visitation rights with the children and the like. It was quite often, the state sodomy law was quite often invoked in court. Well, this person is not a fit mother for this child because she is openly engaged in illegal sexual activity in the state of Georgia. Right? She's now living with a female partner. They admit that they are romantic partners. That's illegal in the state of Georgia, so we deny custody of her children. Right? That kind of thing happened quite regularly. Right? So people, it was unusual to get arrested for directly violating the sodomy law, but the sodomy law still had clearly significant legal effects for gay and lesbian persons. Michael Hardwick found a lawyer. He was represented by the ACLU, in fact. He challenged the law as unconstitutional. He made his way to the Supreme Court of the United States, where he lost 5-4. And the Supreme Court upheld Georgia's criminal prohibition of consensual sodomy. There's a long quote on the handout from Chief Justice Warren Berger. Let's go ahead and read that one. This is from a concurring opinion in Bowers versus Hardwick. What do you guys get from that quote from 1986 from the Chief Justice of the United States, Quentin?
So he's bringing a lot of religious and moral reasons behind it. And I think it's a mistake.
Yeah, it's pretty striking, right? So Quentin said he's bringing a lot of religious and moral reasons into the argument here, right? Condemnation of those practices is firmly rooted in Judeo-Christian moral and ethical standards. Is that... why is he doing that? why is the Chief Justice of the United States doing that?
I think he's really grasping for straws. I mean, he's quoting people whose words were said, centuries ago. He quotes the fact that it was a capital crime under Roman law. Like, you look at these reasons, and you could flip his argument around today as, reasons why we ought to not have any restrictions against homosexual sex, because these ridiculous examples that he's giving are just kind of out there. They don't seem to be very supportive of his claim at all, just that it had been done before in the past.
Yeah.
What I find very ironic is last class we spoke about the idea that Supreme Court doesn't really use overlaws of other countries. He's using other countries' laws to support his argument.
Yeah, so this actually this is a really important point. So remember, we talked about a couple of death penalty cases last week, Atkins versus Virginia and Roper versus Simmons, where the court had struck down the use of the death penalty for certain kinds of criminal defendants, right? People, for example, people who are juveniles when they committed the crime, unconstitutional, violates the 8th Amendment, to execute them if they were not even fully adults, when they committed the crime. And one of the arguments that the court made in those cases is, look, almost every other democratic country in the world has gotten rid of this kind of punishment, right? They don't execute. The only countries that still sometimes execute juveniles are like the Sudan and like China and Yemen and stuff, right? Like the vast majority of the countries that we think of as our peers, right, other constitutional democracies, have abandoned this practice. They consider it to be a cruel and unusual punishment. A similar story plays out in the LGBT rights context. Here, Chief Justice Berger is purporting to say, well, like the whole history of Western civilization has condemned this practice, and so maybe we should learn from that as well. In subsequent cases, other justices look to the practices of other countries and are like, well, maybe they condemned it like 1,000 years ago, but they have stopped condemning it now, right? Just as all of our Western European allies and Canada and other Western constitutional democracies have stopped executing juveniles, they have also stopped criminalizing consensual sexual behavior between two people of the same sex, right? And so subsequent justices point that out, right? Yes, there is some history of condemnation of these sexual acts, but we as a global democratic society, have been moving away from that condemnation.
So, did the lawyers for, I guess, the gay couple here, right?
Mm-hmm.
Did they present facts related to the enforcement of the sodomy laws? Like, okay, was this actually used on the whole population or just homosexual couples?
They did. So one of the things. So this is a concurring opinion here, right? So it's not the majority opinion. This guy's in the majority, but it's just his own separate opinion, just for him, and it's got the most extreme, or whatever the word would be, strident, like anti-gay language in it. The majority opinion, which is written by Justice White, does not go that far. But there's some interesting stuff in the majority opinion too, where if you just read it closely and you think about it, it seems like they're not giving the arguments on behalf of the constitutional protection of LGBT rights very much credence, right? And so one part of that story is the law in Georgia was not about gay people, right? The law applied to everybody. It was illegal for a man and a woman to engage in oral or anal sex in the state of Georgia, punishable by 20-year prison terms. It, in actual fact, did not tend to get enforced against straight couples. It did not hardly ever tend to get enforced against gay couples either, right? And so the lawyers for Michael Hardwick, the lawyers with the ACLU, the case that they tried to make was that this isn't just about gay people, right? This is about everybody, all consenting adults in the state of Georgia, right? They quoted some figures about like what percentage of adult people engage in various kinds of sexual acts, right? They really tried to make the case that this was about the privacy rights, sexual privacy rights of everybody, right? All consenting adults in the state of Georgia. And they basically failed at that, right? If you read the court's majority opinion, they treat it very much as a case about gay people, right? There's a quote from, I have a quote here from Justice White's majority opinion. There is no fundamental right for homosexuals to engage in acts of consensual sodomy. Right? He's just treating it as this is just about gay people, right? The guy in court, Michael Hardwick, is a gay person. He's claiming there's a fundamental right for homosexuals to engage in acts of consensual sodomy. There is no such right. And then he goes on to do something a little bit similar to Berger's kind of historical argument, although not quite as strident. He says prescriptions against that conduct have ancient roots. Sodomy was a criminal offense at common law, that means in English courts at the time of the founding, and was forbidden by the laws of the original 13 states when they ratified the Bill of Rights. In 1868, when the 14th Amendment was ratified, all but 5 of the 37 states had criminal sodomy laws, etc., etc. Now, let me read a line from one of the dissenting opinions, if I have it here. Yeah, this is from Justice Blackmun's dissenting opinion. This case is not about a fundamental right to engage in homosexual sodomy. That is not what this case is about. It is no more about a fundamental right to engage in homosexual sodomy than Stanley versus Georgia was about a fundamental right to watch obscene movies, or Katz versus United States was about a fundamental right to place interstate bets from a telephone booth. Right? That's like the specific factual description of what was happening in this case, but that's not the way you would describe the fundamental right. Right, Katz versus United States is a Fourth Amendment case about whether the police can listen to your phone calls without a warrant. And the answer is no, they cannot. But the question is not, do you have a fundamental right to place interstate bets from a phone booth, right? The question is, do you have a fundamental privacy right to talk on the phone without the police listening to you? Right? The question in this case should be, do you have a fundamental right to engage in private consensual sexual activity without the government interfering with it? And that, if you do have that right, then that right should apply to everybody. Justice Blackmun says, in dissent. Another thing about Berger's quote is, once after this case was decided, and partly because of this case, and partly because of Berger's concurring opinion, there were already academic scholars who wrote about like LGBT history and looked, did what historians do. They dug through different kinds of archives to try to reconstruct as best you can what was going on at particular times, distant from our own. But Berger's concurring opinion, with its sweeping characterizations of like centuries of denunciation of homosexuality, led more historians to do that, to be like, wait, this is like, seems a little over the top. And there's now been a generation of like LGBT historical work that has debunked, or at least complicated, a lot of the things that Chief Justice Berger says. Even if all the historical claims were accurate, we still might want to say, we don't want to make some kind of sexual behavior illegal because somebody else made it illegal 2,000 years ago. Like, you could still say that. But it is also true that he overstates the case with regards to like millennia of moral teachings universally condemning this behavior, right? There was widespread practice of same-sex sexual activity in ancient Greece, right? There are defenses of same-sex sexual activity in Plato's dialogues, right? Central founding texts of Western philosophy. Right? So it is like a little bit just overstated to characterize the history. Obviously, there has been condemnation of homosexuality throughout Western history too, but there hasn't been just condemnation of it. There have also been practices of it and defenses of it. Right? Okay, so that's what the court was saying in the 1980s. I guess one more thing about this case is the justices, at least some of them, maybe all of them, at least some of them, clearly seem to treat the case as kind of parallel to the court's abortion disputes, right? The constitutional issue is basically the same in the two cases. does the word liberty in the Due Process Clause of the 14th Amendment include a woman's right to choose to terminate a pregnancy? Or does the word liberty in the Due Process Clause in the 14th Amendment include a person's right to engage in private consensual sexual behavior of his own choosing? Right, same basic constitutional issue. And in 1986, the court was divided 5-4 on abortion rights, 5-4 in support of abortion rights. And so basically what happened in this case is one justice flipped, right? One justice, Justice Powell, who regularly supported abortion rights at this time, decided that that same constitutional logic did not extend to sexual privacy for gays and lesbians. After he retired, Justice Powell famously gave a speech at a law school where he said that one was a mistake. He's like, I thought about it in recent years, and I think that one was probably wrong. That's one of the ones I wish I could get a do-over on. But he had the deciding vote at the time. And so one of the things that's going on here is they're having arguments about LGBT rights, and the justices in the 1980s don't have that much experience with LGBT rights. In fact, another famous story about the case is Justice Powell during the court's deliberations, and the justices are talking with each other, and they're talking to their clerks about the case and the like. Justice Powell said to one of his clerks that he had never met a gay person, and that clerk was gay, but closeted for some number of years still after, like a decade later, that clerk came out of the closet and told that story. So that's also part of what's going on here. There was a substantially smaller like public presence of out gays and lesbians in the 1980s than there is today, right? There were lots of gays and lesbians, but a great many of them were closeted. And so straight people could walk around thinking that they had never met a gay person, which was probably not true. But in that kind of bubble, that's probably one of the contributing factors that leads the case to come out this way. But for some of the justices, it's clearly, it's a debate not just about gay rights, but it's a debate about this basic approach to the court's protection of fundamental liberties in general, right? So Justice White, for example, who wrote the majority opinion, he was one of the original dissenters in Roe versus Wade, right? Justice White was opposed to the constitutional protection of abortion rights, and he was opposed to the constitutional protection of sexual privacy for gays and lesbians, right? In his mind, for the same basic reason, the court is just kind of making up these constitutional rights. They're not in the constitutional text. I don't see any good enough historical evidence to think that the framers wanted us to protect them, right? And so we shouldn't, on our own, extend the protections of the Constitution to cover these new rights. That's how Justice White was thinking about it. In 2003, the Supreme Court reverses Bowers versus Hardwick in a case called Lawrence versus Texas. And before I get to that one, let me say a couple words about things that happened in between 1986 and 2003. One thing that happened is just cultural changes, right? So there are a lot more openly gay and lesbian people in the United States in 2003 than there are in 1986, both in real life, right, friends and family who you might personally know, and in pop culture, right, so like people on TV who are openly gay and lesbian, either real people or fictional characters. In both cases, there were hardly any in 1986, and there's a lot more in 2003. So for sure, that seems like it's probably part of the story of what's going on. The justices and lawyers and everybody else is more familiar with gay and lesbian people. Part of what's going on is careful legal strategy by LGBT rights advocates, right? So remember the years leading up to Brown versus Board of Education, where Thurgood Marshall and the other lawyers at the NAACP very carefully and incrementally tried to pull the court along one step at a time by first challenging Missouri's complete failure to provide any kind of law school that African Americans were allowed to attend, and then challenging segregation that was being practiced in Texas and Oklahoma in some of their graduate programs, and then challenging undergraduate, whites-only undergraduate admissions at some flagship state universities, and only after a whole bunch of victories then trying to challenge segregation in primary and secondary education. So LGBT rights advocates kind of like regrouped after Bowers, and they're like, we got to start over, and we got to start smaller, and we got to move incrementally to pull the courts along. And one of the things they did is they started litigating in state courts, right? This is something we've talked about at least briefly before. Remember the case of San Antonio versus Rodriguez, which was the school funding case from Texas in 1973, where a majority Latino district was getting way less money for its public schools than a nearby suburban majority white district. And that was challenged under the Equal Protection Clause, and they lost 5-4 in the Supreme Court. And advocates of school funding equity didn't give up. They then started filing very similar lawsuits in state courts, relying on state constitutions. Well, we think the guarantees of equality and right to education in Texas's constitution, not the U.S. Constitution, Texas's constitution, we think those require Texas to equalize the funding. And many of those state suits were successful. LGBT rights advocates do the same thing. And after 1986, they persuade a whole bunch of state Supreme Courts to strike down those states' bans on consensual sodomy. Right, and so substantially fewer, and they persuade some state legislatures to just reverse the bans too, but they also persuade some state courts to do so. So by the time you get to 2003, substantially fewer states are still banning this practice. Right, in 1986 it was about half the states, and in 2003 I think it was 12 or 13. So if the court's going to strike it down, they're not having to rule against as many states when they do so. In 2003, that might make them more willing to do so. Another thing that happens in between the two is some stuff internally on the court going on, where the justices are having arguments with each other about what's the proper way to approach the Constitution, and do we stick with just with the original meaning, or are we allowed to kind of evolve it, or allowed to interpret some of its broad provisions in a way to cover new things, new rights that emerge and the like. The court throughout this period consists almost entirely of Republican justices, right? Remember, Nixon had appointed 4 justices, Ford appointed 1, Carter didn't get any, Reagan appointed 3. There's a period in the late 80s, early 90s where there's only 1 Democratic appointee on the court, and that was Justice White. Justice White's a Kennedy appointee, right, and he's pretty conservative on a lot of issues. So it's a completely Republican court for the most part, but those Republicans, those conservative justices, disagree with each other on a whole bunch of stuff, right? So we saw some of this in the abortion context, where Scalia says over and over again, the Constitution doesn't mention abortion rights, so they're not protected. And Scalia's appointed by Reagan. O'Connor and Kennedy were also appointed by Reagan. And they say something different. They're like, yeah, it doesn't explicitly mention it, but we got these abstract guarantees of liberty and the 14th Amendment. We got to figure out what to do with those. And we do not agree with our colleague, Justice Scalia, that 14th Amendment liberty only applies to those very specific rights that you can identify that the framers themselves directly supported. We don't agree with that. Right? So that came up in the abortion context. It came up in some cases about parental rights, which are not mentioned in the text of the Constitution, but the court has protected in several cases. It came up in a case about, a couple cases about the right to die, right, assisted suicide, right? If you are terminally ill and experiencing significant pain and suffering, should you have a constitutional right to exert some control over the time and manner of your own death? And the justices disagreed on that, right? And there's no right to control the time and manner of your own death in the constitutional text, but maybe it's included within the word liberty in the 14th Amendment, right? So they keep disagreeing on this stuff. And when the sexual privacy issue comes back in Lawrence versus Texas, Court comes out the other way. Justice Kennedy writes the majority opinion. He writes this: Bowers was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers should be and now is overruled. He cites some of the court's abortion cases for active protection of constitutional liberty. He cites developments regarding LGBT rights from other countries, right, where many other Western democracies have decriminalized consensual sexual relations. He mostly just emphasizes his understanding of the court's broad, abstract, evolving conception of constitutional liberty, right, which we have held in many cases, on many occasions, extends to various situations involving sexual activity, procreation, childbearing, marriage, family life, etc. This is another one of those situations. Two people, two adults, engaging in private consensual sexual activity, that is protected by the Due Process Clause of the 14th Amendment. Questions so far? So everything we've talked about so far has been about the Due Process Clause. Also relevant to the protection of LGBT rights, potentially relevant, is the Equal Protection Clause. Right? Both from the 14th Amendment. One of them focused on guaranteeing liberty. No state shall deprive any person of life, liberty, or property without due process of law. And the other one focused on guaranteeing equality, nor deny to any person the equal protection of the laws. And you could see how both of those constitutional principles could apply to LGBT rights. You could see how both of them could apply to the right to marry. Right? In his dissenting opinion in Lawrence versus Texas, Scalia, who was opposed to the decision, he was writing a dissenting opinion. Scalia said, this is terrible, this, here's all the reasons why this decision is wrong, and the next step it's going to lead to is the right to marry for same-sex couples. And the justices in the majority were like, no, we're not talking about the right to marry, that's a whole different question, we haven't addressed that yet, we'll cross that bridge when we come to it. But Scalia predicted accurately that the decision would lead in that direction. And you can think of the arguments, right? So first, you could take the argument that the court uses in Lawrence versus Texas and say, just as the word liberty in the 14th Amendment includes your right to engage in consensual sexual activity, it also includes your right to marry the spouse of your choice, right? Is the right to marry expressly granted by the constitutional text? No. But does it seem to be an important liberty that has long been important to our society and our traditions and fits together in similar ways with other kinds of liberties that we've held protected under the 14th Amendment? For sure, yes. And are there some prior decisions that seem to suggest that the right to marry is protected? For sure, yes. Right? Cases like Loving versus Virginia, which was about interracial marriage. There was a case in the 70s or 80s called Zablocki versus Redhale about the right of prisoners to get married. Right? You don't have the right to live with your spouse if you are in prison, but you do have the right to get legally married. Right? Just because you are currently incarcerated, they cannot deny you the right to legally marry somebody. Right? Maybe the wedding was already planned, right? And then you got arrested, and now you're in jail, and you still want to go forward with the wedding. They have to find. They don't have to let you have like a big fancy wedding in the jail, but they have to find some way to let you get legally married, right? Because the right to marry is a fundamental liberty, the court had said before, right? So you could say the same thing in the same-sex marriage cases, but you could also frame it as an equality issue, right? Wait a minute. most of the people in the country are allowed to get married to the person they want to marry, as long as it is a person of a different sex, right? But if I want to marry a person of the same sex, I am not allowed to do it. That seems unequal. And it seems to violate some principle of equality that is reflected in the 14th Amendment, in addition to the principle of liberty. Based on what we know so far about the court's protection of the Equal Protection Clause, the modern court's protection of the Equal Protection Clause, Brown versus Board of Education forward, basically. Based on what we know about that, what you're the lawyers now. What do you have to do? What kind of arguments do you have to make to persuade the Supreme Court to rule that marriage equality is protected under the Equal Protection Clause? Yeah.
I'd probably try to say marriage affects straight couples the same way it would affect homosexual couples or same-sex couples, so therefore they should be equally protected under the law.
Yeah, that's a really good kind of argument that lawyers do a lot. Like, equal doesn't mean like everything's always the same about everything, right? The principle of equality means that things that are similar in relevant respects should be treated similarly. Things that are different in relevant respects could be treated differently, but things that are similar should be treated similarly, right? And so if marriage is equally important to same-sex couples and opposite-sex couples, then it should be equally available to them. That's a good start. What else? What else would we say as lawyers? Yeah.
So would you need to argue the scrutiny of gender and sex versus race and previous equal protection clause cases, whether or not this is an important enough of an issue to warrant equal protection, or that there are boundaries that exist in gender and sex that need to be protected equally?
Yeah, right? Remember this when we were talking about civil rights cases? So the court has said, sometimes the way they introduce this argument is they say something like this. They say, look, the law treats people differently all the time, right? When you're writing laws, part of what you're trying to do is divide things up and treat some things one way and some things a different way, right? Armed robbery is worse than burglary, right? And so it's going to have a harsher punishment. 16-year-olds are allowed to drive and 15-year-olds are not allowed to drive, right? Ophthalmologists are allowed to perform some kind of medical procedures that opticians are not allowed to perform because they don't have the same level of training, right? The law divides people up all the time, and most of the time that is not suspicious, right? The reason 15-year-olds are not allowed to drive lawfully is not because of some long history of societal discrimination against 15-year-olds, right? That is not why that law is in place, right? But there are some kinds of classifications in the law that seem really suspicious, that we have good reason to be suspicious of. And so the court, in its decisions regarding racial equality, laid out a number of these reasons and said racial classifications in the law are particularly suspect, which is just another way of saying they're suspicious, right? The reason they're particularly suspect is because, we got a long history of racial discrimination in this country. Racial minorities still face prejudice and discrimination today, not just historically, but still today there's prejudice operating against them. The justices also sometimes emphasize that race is a immutable characteristic that you are born with, that you do not choose, and that bears no relationship to your worth as a human being, right? It doesn't tell us anything about who you are as a person or how worthy you are of getting a job or whatever else we might be talking about. So for all those reasons, we're suspicious when the law treats people differently on the basis of race, and since we're suspicious of it, we should look at those laws really closely. and we should only uphold them if the government has a really, really good reason for it, right? So they don't like saying never, right? Like in the First Amendment, they don't like saying free speech is absolute. Sometimes government has a really, really good reason to justify suppression of free speech, but it's got to be a really, really good reason, right? So y'all are still the lawyers. What does the argument look like to persuade the courts that the same kind of strict scrutiny that they extend to laws that treat people differently on the basis of race should also be extended to laws that treat people differently on the basis of sexual orientation? Tom?
I'd also argue that sexual orientation is also an immutable characteristic that is from birth and that you can't change.
Yeah. This is an argument that LGBT rights lawyers make over and over in court, and it's somewhat controversial because it is actually a little bit complicated to figure out where sexual orientation comes from. Many people experience it as something they are born with and that is stable throughout their lives. Some people experience it differently. Some people experience evolution in their sexual orientation over time. Some people, including some scientists, think there is some genetic root to sexual orientation, like they haven't quite figured it out yet, but that if we closely examine everybody's genetic code enough, you could figure out some markers for different sexual orientations. Some people do not think that is the case, and think that it is more something that emerges in your life after you are already born, based on whatever various kinds of factors while you're growing up. So it's complicated, but it is clear, I think this is clear, that for the vast majority of people, sexual orientation is experienced as a core feature of their identity, that they do not feel free to change, that they do not feel like they have openly chosen, right? It feels like something that, whether you're born with it or not, it is something about you that you don't choose. And most of us would agree, although not everybody agrees with this part, but lots of people agree, that sexual orientation bears no relationship to your worth as a human being, right? It doesn't tell us anything about whether you should get a job or not. It doesn't tell us anything about whether you should be allowed to vote or run for office or hold any particular kinds of positions in society or economy or whatever. Sometimes people have tried to compare sexual orientation to religion on this front, right? You're not really born with a religion, right? It is not genetic, for sure. But many people grow up with one from early on, and many people experience their religion as a core feature of their identity that they didn't really actively choose, just something that they had from the beginning. Some people do change their religions. Sometimes it is possible. People do it. But it's, for many of us, a core feature of our identities that bears no relationship, again, to our ability to perform in society, no relationship to whether we should have a job or not, or any other form of discrimination. So that's one good part of an argument, right, to say that just as we're suspicious of laws that treat people differently on the basis of race, we're also suspicious of laws that treat people differently on the basis of sexual orientation. What else do you say as lawyers to extend this line of decisions? Right? This is what lawyers do. They take decisions that already exist and they try to persuade courts to extend them or cut back on them. Right? They say, well, I know you did this in these cases and this new case is similar and here's why it is and you should extend it. What else do you say here? Persuade the court to extend strict scrutiny under the Equal Protection Clause to, for example, laws that only allow opposite-sex couples to marry. What else might help you win that case?
I guess just like the legitimacy of differences between two groups. Like, you say that their race ought to have strict scrutiny because it's an immutable part of somebody's identity, and because somebody's race does not determine like their ability. So without like any evidence that shows, homosexual couples are, well, nowadays they like to present evidence like they're worse parents, or for example, right? But without that kind of evidence that shows that the couples are just less desirable on some societal level, then there is no reason to have distinct ways that you treat them.
Yeah, in some of the early marriage cases, so the early marriage cases were all filed in state courts, right? Same as with the school finance and the sodomy cases we were talking about. They said, okay, we're going to build up step by step. Let's start with some state courts. So we're going to file a case in Hawaii and in Alaska and in Vermont, and try to persuade these state courts to move towards marriage equality first. And in those early cases, state officials often tried to defend their discriminatory marriage laws by saying that actually there was good reason to treat gays and lesbians unequally because, for example, they're not as fit to be parents, right? So the lawyers for the state governments would say that in court. And the lawyers for the other side would say that is not true, and they would introduce evidence, and then scholars would start to perform more studies to help these cases moving forward, and there is now quite a substantial amount of social scientific evidence showing that there are no systematic differences between the quality of parenting provided by gay and lesbian people or straight people, right? So again, there's no relevant differences. It shouldn't be treated differently, right? It seems to violate a principle of equality. If people who are basically the same for all relevant respects are being treated differently. Right? What else would you want to say in court?
Kind of going back to the striking down of interracial marriages. Again, race is again something you can't choose. Gender is also something you can't choose. So how can you deny someone, the right to marry based on something they can't really choose?
Yeah, the interracial marriage cases come up a lot in these cases, right? It's the same basic right? It's the right to marry. Fundamental right to marry is being denied, and to many people it seems parallel in many respects. For what it's worth, too, defenders of bans on interracial marriage throughout American history up until the 1960s regularly defended those bans in religious language, right? Language that doesn't sound all that different from Chief Justice Berger's concurring opinion in Bowers versus Hardwick, right? It's always been, God-given belief that, the races are meant to be separate. They're not supposed to intermingle, right? Our blood is meant to be separate. It's not supposed to intermingle. That's the way we have always done it. That is the way God commanded it. And you can find some passage from the Bible that you can read to try to support that, right? And the court overcomes that, and they're like, no, that's not good enough justification for this fundamental unequal treatment. And so that example seems like it applies pretty directly here as well. Go back for a second, if you can, to cases like Frontiero versus Richardson in 1973. So the court in the 50s and 60s has a bunch of cases saying the Equal Protection Clause prohibits racial discrimination in the law, and so we're going to strictly scrutinize any law that treats people differently on the basis of race. And then lawyers like Ruth Bader Ginsburg start trying to persuade the court that laws that treat men and women differently should also be strictly scrutinized. What does she argue in those cases? cases like Reed versus Reed and Frontier versus Richardson and Craig versus Boren, she persuades the court to, well, actually, she doesn't quite persuade the court to apply strict scrutiny to gender. But she does persuade them to invent a new intermediate standard of scrutiny where laws that discriminate on the basis of gender are treated almost the same as laws that discriminate on the basis of race. How does she get the court there? Remember, there are cases like military pension rules applied differently to servicemen and servicewomen. So Sharon Frontiero was a lieutenant in the Air Force, if memory serves. And her husband was not entitled to the same family benefits, pension benefits, retirement benefits, survivors benefits, etc., as he would have been if she were a man and he were a woman. The Supreme Court strikes that down. How does Ginsburg persuade the court to do that? So we've already hit on some of her key arguments for sure, but there's more here. Why does lawyer Ruth Bader Ginsburg think we should be particularly suspicious of this law that treats Lieutenant Frontiero unfairly? Yeah.
Was it because she claimed that our nation has a history of being discriminatory based on sex, and that sex is like race, and that it's like immutable, so you can't, and it's solely determined by birth, so there should be like semi-suspect classifications.
That's right. And the immutability part we already hit on, but the history of discrimination part, that's another key argument, right? One of the reasons, not the only reason, but one of the reasons that we are suspicious of laws that discriminate on the basis of race is because of our nation's history. Well, look at our nation's history. Do we have good reason to be suspicious of laws that discriminate on the basis of race? I think the answer is yes. Right? And what Ginsburg does as a lawyer is she says, look at our nation's history. Do we have good reason to be suspicious of laws that discriminate on the basis of sex or gender? She's like, yes, on that one too. Right? There's a whole long history of laws preventing women from voting, or running for office, or serving on juries, or holding certain occupations. Remember Bradwell versus Illinois in the 1870s. Women were not allowed to be lawyers in Illinois. Right? There's a whole long history of this kind of discrimination. And it is rooted in prejudice. Right? It is rooted in ideas that are not justified about different roles for men and women, right? Different places for men and women, right? A woman's place is in the home, not being a lawyer, right? We got a long history of that. So if we see a law today, we don't still have laws today that say women can't be lawyers, but we still got a law today in 1973 that says women in the Air Force don't get paid as much. Basically what it says, they and their families don't get the same employment benefits that a man in the Air Force would get, right? Given our history of sex discrimination, we should be suspicious of that law. And we should look at it real closely. And maybe if the government has a really good reason, okay, maybe they could justify it somehow. But we're going to look at it real closely. We're going to strictly scrutinize it. Well, LGBT rights lawyers say all of those same things. Do we have a long history of discrimination against gays and lesbians? Yes! Right? Look at Chief Justice Berger's concurring opinion on the Supreme Court. Look at that. That's some history of discrimination against gays and lesbians right there. Right? We got a long history of it. Right? And have we gotten past some of the worst of it? Maybe so. But is some of it still there? Yes. And so if we see a law that discriminates on the basis of sexual orientation, we should be suspicious of it. Maybe if the government's got a really good reason, maybe they could uphold it. But they're going to have to come up with a really good reason because we should strictly scrutinize it. This is an argument that LGBT rights lawyers make over and over and over again in court in the 1980s. After Bowers versus Hardwick. Bowers, remember, doesn't address any of these issues because it's focused on the Due Process Clause, not the Equal Protection Clause. Right? So it's not about unequal treatment. It's just about the right to privacy. After Bowers, LGBT rights lawyers make these arguments over and over and over again in court. There's a big set of cases in the 80s and 90s focused on the military's exclusion of gays and lesbians from service. Under long-standing military policies dating that the current version of them at the time dated to like the Cold War. There was, in addition to trying to purge communists from the U.S. government, there were a bunch of efforts to purge gays and lesbians from both civilian and military employment in the 1950s. And those policies were still in place in the 80s. And gay rights advocates tried challenging them. There were gays and lesbians in the military, but if they got found out, they would get kicked out, and then the lawyers would try to challenge them. When Bill Clinton got elected, he said he was going to change that policy, but then Republicans in Congress and some Democrats in Congress rebelled, and he wasn't able to repeal it, and they wound up adopting a compromise, they called it, which was called Don't Ask, Don't Tell, which supposedly said that you could continue to serve in the military. If you were gay or lesbian, you just couldn't tell anybody, right? So you weren't allowed to openly serve. And so again, people would get found out and then get kicked out. And again, those policies were challenged. And then starting in the early 1990s, gay rights advocates start to file marriage equality lawsuits. And in all of these different cases, they argue this, that laws that discriminate on the basis of sexual orientation, we should be suspicious of them for lots of the same kinds of reasons that we are suspicious of laws that discriminate on the basis of race or gender, and so the court should strictly scrutinize them. That argument has never yet worked. Right? The Supreme Court has never adopted that argument. At first, the Supreme Court was never ruling in favor of LGBT rights at all, right? All of those military cases in the 80s and 90s were unsuccessful, right? Those were not Supreme Court decisions, those were lower court decisions, but they were all unsuccessful. Over time, the Supreme Court starts to protect gay rights in a variety of different kinds of cases, but it has so far moved really incrementally and cautiously, and it's gotten pretty far now, right? Marriage equality nationwide, that's a lot of, it's gotten pretty far, but still in terms of what it is willing to say explicitly about how the Constitution protects gay rights, the court has still moved really cautiously and incrementally, and they have never said this, right? Let me give you a couple examples. There's a case in 1996, which is not about marriage equality, but it's the first important decision from the Supreme Court applying the Equal Protection Clause to LGBT rights. It's called Romer versus Evans. It's from Colorado. Colorado, like a lot of states out west, they have like a ballot initiative process where you can put a law on the books or even amend the state constitution by circulating petitions. You get a certain number of signatures, and then it goes on the ballot, and then if a majority of voters vote for it, then it goes in there. And so Colorado voters had amended their state constitution to say that no part of the government of Colorado at the state level or any local level, right? So no state, local, county, governmental unit of any kind in the state of Colorado is allowed to protect people from discrimination on the basis of sexual orientation. Right? 3 cities in Colorado had passed laws that said in our city, like in Boulder or whatever, it's illegal to discriminate in like housing or employment on the basis of sexual orientation. So you can't refuse to rent somebody an apartment because they're gay. You can't fire somebody from their job in Boulder because they're gay. And this state constitutional amendment overturned those 3 local laws and said that those cities and any other cities in the state could not adopt any other similar laws in the future forever unless the Constitution were amended again. And the Supreme Court strikes this down. Supreme Court strikes this down. And the LGBT rights lawyers tried to argue that this is blatant discrimination on the basis of sexual orientation. It should be strictly scrutinized, like laws that discriminate on the basis of race. Or if the court's not willing to go there, it should at least be subject to an intermediate level of scrutiny, like laws that discriminate on the basis of gender. Or if the court's not willing to go there, even if the court applies its most minimal level of scrutiny, this law is still unconstitutional. The minimal scrutiny is what the court would apply to like a law that says 16-year-olds can drive and 15-year-olds can't. Or ophthalmologists can perform certain kinds of medical procedures that opticians are not allowed to perform. Right? It's a law that treats 2 different groups of people differently, but not for any reason that we have reason to be suspicious of. And that's all the Supreme Court did. They said, well, okay, but some people have said sexual orientation should be a suspect classification. I don't know. That's a complicated argument. We're not going to address that today. But this law in Colorado, this state constitutional amendment in Colorado, is so blatantly discriminatory. Whoa. This constitutional amendment in Colorado is so blatantly discriminatory that somebody can close that if they want. That even if we don't strictly scrutinize it, it is still unconstitutional. Right? So that is a victory for LGBT rights. It got rid of this discriminatory law in Colorado, but it is a really small, like incremental victory that does not answer the question that the lawyers were trying to get the court to answer, which was, do these discriminatory laws get subject to the same kind of strict scrutiny? The court doesn't answer it. Likewise, in the marriage cases, the court moves cautiously and incrementally and has done some really important stuff, but has still not answered this big picture question about the Constitution's protection of LGBT rights. So again, the marriage cases, they start at the state level, which is on purpose from the gay rights advocates. In fact, the cases first start just with like some ordinary people, right? There's 3 same-sex couples in Hawaii who want to get married. They are not allowed to get married. There's all kinds of legal rights and economic benefits that are associated with marriage, and they don't have access to those. And they hire a lawyer in Hawaii to sue the state. And like the national gay rights organizations were not even involved in it. But that case starts going forward, and the Hawaii Supreme Court rules in their favor in like a preliminary ruling. It still didn't fundamentally decide the case yet. It wasn't final yet. But they seem to be suggesting that maybe Hawaii's discriminatory marriage laws might be unconstitutional. So then the national gay rights groups all get involved in it, and they intentionally file some more cases in state courts because they are looking at the federal courts, which are the courts that decided Bowers versus Hardwick, and they're like, I don't think we're going to win there, but maybe some of these state courts would be willing to go for these arguments. And then over time, cautiously, incrementally, they persuade several state Supreme Courts to legalize marriage equality. The first one to rule definitively in their favor is the Supreme Court of Vermont. But they say, you got to give them all the legal rights of marriage, but you could call it something different if the state wants to. And so Vermont is the first state that sets up a civil union law, which is basically like straight couples can get married, gay couples can join a civil union. They are the same thing for purposes of the state benefits, but they're going to be called something different. That's what Vermont does. And then the Massachusetts Supreme Court is the first one to rule really definitively in their favor and say, no, it has to be full marriage equality. And so then you have a system where there's a couple states in the country where gays and lesbians are allowed to get married. And in most of the country, they are not allowed to get married. And most of the states in the country pass laws that say, not only are we not allowing same-sex couples to get married in our state, but we're not going to recognize same-sex marriages from other states. And Congress passes a law that says we are not going to recognize, federal government's not going to recognize marriages of same-sex couples. And so now all of a sudden you've got thousands of couples in states like Massachusetts and California who are legally married in their state, but those marriages are not recognized by the federal government or by other states. And so the next thing that the gay rights advocates do, remember, think about the NAACP lawyers leading up to Brown. Like, how can we do this? Like, persuade the courts if we move kind of one step at a time. So we've persuaded several state Supreme Courts to legalize marriage equality. Then they go back to federal court and they say, they don't say right to marry, they say the federal government's refusal to recognize lawful same-sex marriages from Massachusetts when it recognizes lawful opposite-sex marriages from Massachusetts. And as far as the state of Massachusetts is concerned, they're the same thing. Everybody's allowed to get married in Massachusetts. Federal government recognizes some of them but not others. That violates the Equal Protection Clause. Right? So the fact that you are lawfully married in Massachusetts but the federal government says you don't get any Social Security benefits, or like immigration rules about being able to sponsor your spouse for immigration to the United States, nope, you don't get that either. Anything that's about federal law, you are not considered married. That violates the Equal Protection Clause. The Supreme Court says in Windsor versus United States. That does not let any same-sex couples in Texas get married. Right? That just says if you live in a state where you are allowed to get married and the federal government is refusing to recognize that marriage as legal solely because you are both of the same sex, that violates the Equal Protection Clause. So that's an incremental step. Right? And then the gay rights advocates come back with another case, which is called Obergefell versus Hodges. And in that one, they're like, okay, now, building on what you said in Windsor about the fundamental right to marry and equal treatment for gays and lesbians, now we think under the 14th Amendment, gays and lesbians have a fundamental right to marry, and these discriminatory marriage laws in Texas or Oklahoma or wherever else they still are, those laws violate the 14th Amendment. And then that argument is finally successful in Obergefell, which is in 2015. The court still does not answer this question. The court still doesn't do this. Questions about that? So now, if you were going to try to craft an argument as to why, over the past 30 years, the court had gone from tolerating blatant deprivations of liberty for gays and lesbians in Bowers to a fairly sweeping ruling legalizing marriage equality for same-sex couples throughout the country. Why did the court do that? What would you emphasize? It's a story of pretty rapid constitutional change. Not overnight, takes some years, but in a couple decades, pretty rapid. Yeah, what would you emphasize?
I would say most important is the change in consensus, like how many states and how many people are for or against gay marriage. And then to support that precedence that was built by the previous cases.
Yeah, so two important points. Let's take the first one first. So consensus, how many states are recognizing same-sex marriage versus how many are not recognizing it? Why do you think that's an important part of the story?
Well, I think that even if we like to say that the justices are like separate from politics. They're still very influenced by the nation's approach to things, and even if it's not on like a Republican or Democratic level, they can approach it on a state-by-state level. Like, okay, federal government sometimes chooses what ought to take place based on what states think. And so if we see like many states getting rid of their discriminatory laws towards gay couples, then it tends to show like a national progression, like in the death penalty cases,
Yep.
right?
Yep. Yeah, no, the court mentioned this explicitly in those death penalty cases we talked about last week, right? The fact is, we have some states that don't use capital punishment at all, but even the states that use capital punishment, most of them have gotten rid of it for juveniles, right? And the trend is consistently in one direction. Like, no states have been reinstating it for juveniles, right? Some states still have it, but every couple years another one has gotten rid of it. And the trend is clearly in the direction of this is a practice that no longer makes any sense, right? There is a clear line of development in our nation's laws moving in the direction that we are now just like pushing over the final hurdle or whatever, right? Think about Bowers versus Hardwick, right? About half the states, I think it was 25, 26 states, had laws similar to Georgia's law at that time, and the court decides not to strike them down, right? Whatever it is, 17 years later or something, only about a dozen states still had those laws, and now the court strikes them down, right? It's not as much of a lift for the court to say the Constitution prohibits this kind of discriminatory policy that like a quarter of the states are doing, right? Whereas if the Constitution prohibits this discriminatory policy that half the states are doing, that's a bolder thing for the court to have to do, right? That seems like an important part of the story, right? And then the second thing you mentioned is just the case-by-case precedents built up over time, right? So yeah, another important part of the story, right? If you had gone to the Supreme Court in 1986 and said, we think there's a fundamental right for same-sex couples to get married nationally, obviously you would have lost, right, in 1986. Same is true in 87, 88, 89, 90, for a lot of years thereafter. If you had just jumped in there with that sweeping argument, you would have lost, right? But like Thurgood Marshall and school segregation, if you can build up some precedent case by case by incrementally chipping away at some of the discriminatory practices, right, you might be able to eventually get the court to where you're trying to go. What else would you emphasize? Why did the court over this 20-30 year period move the Constitution significantly in the direction of protecting LGBT rights? What else seems an important part of this story? For sure, those of you who are writing about LGBT rights for paper 3 should be thinking about this. But regardless of what topic you're writing about, right, this is basically something you should be thinking about, right? Because if you're writing about the 4th Amendment or the 8th Amendment or the freedom of speech or the freedom of religion, right, part of what I want you to try to do in these papers is think through, has there been a clear line of change? It's not always this clear of a trajectory, right? Sometimes it's more fits and starts. But has there been a clear line of change? And why do we think that has been taking place? And there's probably lots of different kinds of reasons. But can you pull out a couple of the threads and emphasize them? Like, which ones, in this particular area of the law, which ones seem particularly significant and why? could think about it like if it were an essay question on an exam, right? Without any of the specific cases in front of you, right? You don't have all the details of everything that the lawyer said and the justices said in front of you. But what would be the general story that you could tell to explain why the court has moved the law in a particular direction during a particular period of time? Colin?
I mean, you could elaborate on the constitution of the Supreme Court itself, how it's changed over time, and how,
Sure.
you know, with a Supreme Court that's been more accepting to progressive, you know, towards progressive ideology, how that has played a role, and like how the stars kind of aligned when Obama was president and had a more liberal Supreme Court than there has been, or it exists now, perhaps. How that was kind of created the conditions for change.
Really important, right? Sometimes the story is in part about who are the judges, right? In 1986, the judges were almost all Republican appointees. Not all of them. There were still, Thurgood Marshall was still there in 1986, right? But there was a clear conservative majority, which through the 80s, through the end of the first Bush presidency, that conservative majority just continued to grow. But then Bill Clinton appointed 2 justices, and Barack Obama appointed 2 justices, all 4 of whom are still on the court, right? That's probably part of the story, right? Bill Clinton and Barack Obama were more supportive of LGBT rights than than all of our other presidents have been, right? And so it wouldn't be surprising if the judges that they nominated were also more supportive of LGBT rights. That probably can't explain the whole story, because that's only 4, right? There's 4 Democratic appointees on the court. They've been supportive of gay rights since they got on the court. That's not enough to decide something. But that could be a big part of the story, right? Okay, and they're joined by Justice Kennedy in some cases, and they're joined by Justice O'Connor in some cases. So some of the conservative or moderately conservative Republican appointees are willing to support gay rights too. But part of the story is that you got more liberal Democrats on the court who are willing to do this. Part of the story in the Obama era, part of the story with marriage equality, is also that the presidential administration itself is willing to support the rights claims, right? So both, meaning the president himself, right? So this is famous. Barack Obama, the first time he ran for president, was quite supportive of gay rights in many ways, but when you asked him about same-sex marriage, he would say he wasn't there yet, right? And most people, a lot of people thought that was like political, right? The country wasn't there yet, and so it's too controversial for him to say he supports it. But during his second term in office, he declared that he supported full marriage equality. And his Attorney General, Eric Holder, declared that the Federal Justice Department supported full marriage equality. And they thought that based on the precedents like Romer versus Evans and Lawrence versus Texas and these other cases that the court had decided, they thought those same principles now extended to cover marriage equality too. And so that means when the issue reaches the Supreme Court, right, the Solicitor General of the United States is weighing in support of marriage equality. That part probably plays a role in the story too. Right? So there's lots of different factors that play into it. For purposes of paper number 3, regardless of what topic you're writing about, try to spend some time thinking about what are the different factors that seem to play the biggest role in that area that you're focused on. That's all.